Hello everyone. In this session, I am going to explaining about essential elements of the valid contract. Contract. Contract is an agreement which are enforceable by law. In simple words, all the agreement is not treated as a contract. The agreement should be enforceable by law is called as the contract. Similarly, the contract should create the legal relationship between the parties. If any contract create the relationship like a bed relationship and the agreement between the friends are not treated as a contract because it does not create any legal relationship. For example, A agreed to sell his house to B. It is a legal agreement because here there are two parties are available. One of the party is called as seller and another one is called as buyer. Here, the legal relationship arises between the Mr. A and Mr. B. However, the father promised to pay some of amount to his son for as a pocket money. It is not a contract. Here, there is no legal relationship arised. Here, father and son blood relationship arised. So, it is not treated as a contract. So, the contract must have two important elements. One is called as an agreement. That agreement should have enforceable by the law. Enforceable by the law means if any one of the party is aggrieved, that aggrieved party have right to file a case against the another party is called as enforceable by law. The contract, it should be enforceable by the law. It should be fulfill the following 9 conditions. Namely, it should have a proper offer and acceptance. It should create the legal relationship between the parties, and there should be a legal and lawful consideration. The parties to the contract having the capacity to enter into the contract with a free consent, and the purpose of the contract should be a lawful one, and the performance should be a possible one. It is not declared void by any of the law, and it should follow the legal formalities. Now I am going to explain each and every point in a detailed manner. Offer and acceptance. The contract starts with the offer and end with accepted by someone person. So the offer and acceptance is an essential part of the contract. There must be two parties of an agreement. One party making the offer and other party accepting the same. The term of offer should be a specific one and unconditional one. The acceptance must also, according to the mode prescribed, and must be communicated to the offerer. The offer should give a definite offer. For example, A agreed to sell his red color Scorpio car to Mr. B. It is a valid offer because he mentioned the color of the car and the brand of the car. It is easily accepted by the Mr. B. Is called as offer and acceptance. Here, the A is the offerer and B is called as the acceptor. So, the offer should be a simple, clear, and does not create any confusion. Accepted. Similarly, the B should accept the same offer. A agreed to sell his red color car, but B ready to accept his white color car is not an accepted one because there is no proper intention. There is no clear intention between the two parties are there. So the offer should be specific one. It should be accepted by the person only. It's called as offer and acceptance. The next one is called as intention to create legal relationship. When two parties are enter into the contract, we must ready to create the legal relationship. A valid contract requires that both the parties have clear intention to create the legal relationship. This means that must agree with the understanding that if one party fails to give their promise, the other party can take the legal action. Similarly, the actions related to the or the agreement related to the personal or family situation is not treated as a contract. For example, husband promising to take his wife on a vacation. Similarly, a friend agreeing to help another friend with studies is not considered as a legal contract. It is created out of the love, out of the trust, and out of the friendship. So it is not treated as a contract. It does not create any legal relationship. So the family or social agreements are not considered as a legal one. For example, A invite his friends B to come and stay with him for a week. B accepts the invitation, but when he comes to A cannot accommodate him as his wife had died on the day before. B cannot claim any compensation from A as an agreement because this agreement carried as a social one. Similarly, a father promises to pay his son rupees 100 every month as a pocket allowance. Later, he refuses to pay. The son cannot recover from any claim from this contract because it is a domestic agreement and there is no intention on the part of the one parties to create the legal relationship. So, the agreement should create the legal relationship among the parties. The next one is called as lawful consideration. Consideration means something in return. Without the consideration, there is no contract. An agreement is enforceable by law. It must be supported by the consideration. So consideration means something in return. It also known as advantages or benefits moving from one party to the another party. So something return means you must give some value. It does not mean that you are not pay only for cash or kind. Considerations also need that intention to do or not to do something. Similarly, consideration may be past, present, or future. For example, A sell the goods to the B. Take example, A agreed to sell his laptop, his to B. For that, consideration include B pay rupees 10,000 as cash. Otherwise, instead of cash, he can pay his PC, that is personal committed to A. It is also treated as a consideration. Similarly, instead of cash or kind, A agreed to carry out his project. I mean, his project means a project without his any intentions. Is also considered as a consideration. So the consideration means any cash or any kind or any act or any activities not done by him is called as consideration. But the consideration should be a lawful one. For example, A purchased the laptop from B. For that purpose, B agreed to pay something stolen property is not considered as a lawful consideration. And next one is called as capacity of the parties. The parties to the agreement must be capable into entering into a valid contract. Capacity refers to a person having the age of majority. That is, he is not a minor. It is of the sound mind. That means that the person is not in the form of idiot, lunatic, or drunkard. And third important one is not disqualified from contracting by any law. For example, if the person is not declared as insolvent by any of the law. So, if you are entering into the contract, you must check whether the person is a major one and is a sound mind and is not disqualified by any laws. The flaw in capacity conduct may be arise from minority, lunacy, idiocy, drunkenness, and the status. For example, if you enter into the contract with a minor, that contract is void. At the same time, if you are entering into the contract with the minor for the purpose of supplying necessary goods, it is also treated as a capacity to enter into the party. At the time, the contract with the minor is also valid one. So before entering into the contract, you must check whether the contract person is having the capacity. And next one is called as free consent. The contract should be made without any compulsory. We have to made it with in voluntary form. So it is essential to the creation of every contract that there must be free and genuine consent of the parties of the agreement. The consent of the parties is to be free when they are of the same mind of all the material terms of the contract. The parties are set to the same mind when they agree upon the same subject in the same manner. This absence of free consent in the agreement induced coercion, undue influence, fraud, misrepresentation. For example, A acquired the property from the B by the way of forcing or by the coercing the someone else or kidnapping his sons and make them compelled to enter into the contract is not treated as a contract and it becoming the void one. So before entering into the contract, you must be enter the contract voluntarily without the any conditions. And next one is called as lawful object. The object of the agreement should be a lawful one. It should be a legal one. A contract involved illegal activities is not treated as a valid contract. For example, the contract related to illegal, immoral, opposed to public policy is not treated as a valid contract. It is suffers from any legal flow. It must not be enforceable by law. For example, A stolen the some jewels and he sold it to someone else. It is not a legal object, and that property of the contract should be not enforceable by the way. For example, stealing or smuggling is not a valid contract. And next one is called as possibility of the performance. Performance of the contract means it is possible to carry out the work. The agreement must be contained and not vague and indefinite. If it is vague, it is not impossible to ascertain its meaning. It cannot be enforced. For example, A agreed to sell B 100 tons of oil. In this case, B does not mention the which kind of oils. So oil may be a crude oil or any cooking oil, etc. So this kind of agreement is not a clear one. Therefore, it is not valid in the form of the conditions. Similarly, some of the persons are making the agreement. I agreed to bring the sky, bring the stars from the sky is not a valid contract because it is not possible to do it. So, if the contract is having about impossible performance, it is not possible to encourage it. And similarly, it is not declared void by law. Some types of agreements are not allowed by the law and are considered by void. For example, selling the lottery ticket in Tamil Nadu is banned by the Tamil Nadu government. So, if any person involving in the lottery business, that contract is not a valid one. So, the agreement must not have been expressly declared void by the law in force of the country or the particular regions. Is called as not declared void by the law. And last topic is called as legal formalities. A contract may be made by words or spoken or written, but some of the contracts should be made in a specific format only. For example, if we buy the properties from the other person, it must be properly registered. The registration must be carried out in the stamp papers, and both the parties, that is offerer and acceptor, that is the seller and buyer, must sign in the all the documents paper, and it should be properly registered in the register office. If any one of the formalities are missing, that contract is not a void one. So if you follow some specific contract, that contract rules also followed. If any defects are there, it is not possible to impose it. For example, if the check is drawn, we must be signature of the drawer, the amount in the words and the figure should be tally once, and the signature should be matched with the specimen signature of the bank. If it is not available in the check, the bankers can return it. Nobody cannot claim for this. It's called as legal formalities. These are the main essential elements of the valid contract. Once again, I repeat the headings of the essential elements: offer and acceptance, intention to create legal relationship, lawful consideration, capacity of the parties, free and genuine consent, lawful object, agreement not declared void, certainty and possibility of the performance, and legal formalities. Thank you.